Good morning, Your Excellency.
Good morning, Alia. Good morning, Mr. Chaudhary and Mr. Yates.
Good morning, Your Honor.
Good morning, Your Excellency.
I believe the parties are ready to proceed, Your Excellency.
Yes. Thank you. Well, I think we stop where we have to cross-examine the witness, the second defendant of your Mr. Chaudhary. So, Mr. Yates, you still would like to cross-examine the witness?
Yes, sir. Yes, Your Honor.
Yes. Mr. Chaudhary, you may call your witness.
Yes, thank you, Your Excellency. Your Excellency, may I, with your leave, may I then request Mr. Jayaprakash Narayan, who has already logged in, to switch on his camera and unmute himself.
Morning, Your Honor.
Good morning.
May I proceed to swear in the witness, Your Excellency?
Yes, please.
Thank you. Can you please confirm to the court whether you will be swearing in by oath or by affirmation?
Sorry, I don't understand these two differences.
Swearing in by oath means that you will have a copy of your holy book with you. You will place your hand on it and swear in that way. Affirmation is a series of words that you will affirm that you will say nothing but the truth.
Thank you. For affirmation, yes.
Thank you. Please confirm your full name and occupation for the court's record.
Yeah, Jayaprakash Narayan. I'm a banker and chartered accountant.
Thank you. Please repeat after me. I affirm
I affirm
that I will say nothing but the truth.
there's truth and nothing but the truth.
No,
Thank you.
You gotta him repeat, please.
Sure. Please repeat after me. I affirm
I affirm
that I will say
that I will say
nothing
nothing
but
but
the truth.
the truth.
Thank you. Thank you,
Thank you very
Excellency.
much.
Thank you very much, Mr. Narayan. Can we call you Mr. Narayan?
Sure, you can.
That's
Thanks, sir.
great.
Thank you, Madhani.
That's great. Are you alone in the room?
Yes.
Okay, please make sure you didn't receive any information or answer from the surrounding.
Sure.
So the answer should be yours.
Absolutely.
Okay, so you will be subject to be cross-examined by your opponent and then try to answer according to the questions.
Sure.
Okay, and I will leave you to your counsel now, and he will advise you in how you do this. Thank you. Mr. Chaudhary?
Thank you, Your Excellency. Mr. Narayan, on the screen is my learned friend, Mr. Sean Yates. He is counsel for the claimant. He will now be cross-examining you. Please wait for him to finish his question and then answer that question and no other question. Please listen to it carefully. If you do not understand anything, or if there's any issue with the transmission of the words because of internet connectivity issues, you can absolutely ask him to repeat the question. But you must pay attention to the question and answer only that question. Does that make sense?
Thank you, sir. Sure.
Yes, please proceed to be cross-examined. Thank you, Mr. Yates.
Your Honor, I wonder if Mr. Chaudhary might want to take the witness to his witness statement to get confirmation that he agrees with the facts of that first.
Yes, of course.
Yes.
Do you have access to the bundle, Mr. Narayan?
Yes.
Yes. If you turn to page 52 of that 151-page bundle.
Yeah.
Do you see page 52 on the top right corner in red ink?
Yes.
Yes. If you see about a third way down that page 52, it says the witness statement of Mr. Jayaprakash Narayan.
Yeah.
If you see the bottom left corner of that page, it has what might be called initials. Are these your initials at the bottom of that page? The subsequent page, that is page 53 as well?
Yes.
And now can you turn to page 54?
Yeah.
You see it says there's some handwritten annotation. Is that your signature?
Yes.
In what looks like dark gray ink or black green ink?
Yes.
Are these, is this document the witness statement that you have submitted in these proceedings?
Yes.
Thank you.
Is there anything you would like to draw the court attention, anything in your witness statement that worth changing or giving no or anything else?
No, Millard, I think, Your Honor, I think as we proceed with the witness statement and counter from the learned lawyer, I'll be happy to give the responses. If there is anything, I can always add on and take your permission.
Thank you. Mr. Yates, the witness is yours.
Thank you. Good morning, Mr. Narayan. Can I check that you have in front of you a bundle? Do you have a written copy, the hard copy, or are you looking at a screen?
No, I'm looking at the hard copy.
The hard copy. Okay, so to make sure that I'm going to be taking you to the right page numbers, that we have the correct bundle.
Yeah.
The bundle that I have, the last page is, as Mr. Chowdhury said, 151. So you should have 151 pages to that bundle.
Yes.
Is that right? Okay, good. Now, you said that there weren't any things that you wanted to change, but your witness statement does refer to the suggested illegality of the agreement. But I understand that you're no longer taking that position.
Do you want to refer to a particular para which you are talking about?
But yes, if we look at your, do you have your witness statement in front of you?
Yes.
Okay, well, there's a paragraph on the first page, which is paragraph 5 on page 52, and you say the claimant itself lacks the necessary legal capacity to engage in referral or commission-based activities under the scope of its business license. This renders the agreement void ab initio and unenforceable, but you're no longer taking that position. Is that right?
I will. This was my legal advice based on the documentation review, and this was found based on that basis. I'm not aware of all the conversation that happened after in yesterday's event, and I can't comment on that. But this is what was based on the legal support at that time when you were drafting this.
Were you here yesterday at the hearing?
Yeah. Sorry?
Were you here yesterday at the hearing?
Initially, yes, but then I have to go because that is how it was organized.
Okay. If you turn now, please, to the last page of your statement, which is on page 54, paragraph 22, you say in similar vein that the claimant's attempt to enforce an illegal and unfair agreement should be dismissed. So would you accept that you're no longer taking the position that this is an illegal agreement?
Again, I'm saying that yesterday's events I'm not aware, but this is where it was because lots of content of this claim were not tenable, and that's where the statement came from.
You're a compliance expert, Mr. Narayan, aren't you?
Yes.
You don't go around as a compliance expert entering into illegal agreements, presumably.
Yes.
Can I ask you please to look at page 57 of the bundle? You'll find there the professional license of the first defendant, which is your company.
Yep.
And we see from there that you are 50% owner of this company, along with Utkarsh Singh Jayaprakash.
Yep.
Is that a relative of yours?
Yes.
Who is it?
It's my son.
Your son. So you have the 50% ownership. You're also the Mudir on the license, so you're the manager.
Yep.
And you were a director.
Yep.
And you took a salary from the company.
At that stage, no, because it depends on the performance of the company. How much does it do?
Did you ever take a salary from the company?
No.
did you have an employment contract with the company?
No.
So as the general manager of the company, you didn't give yourself an employment contract?
It's not that, I mean, it's basically ownership. These are the boutique consulting firm formed by the consultant day in, day out, who want to run is an individual single person run entity. This is how Dubai has lots of them.
So this is a professional license, isn't it?
Yeah.
If we look at the referral agreement, which comes 2 pages later, that's on page 59.
Yeah.
You recognize this document?
Yeah.
And you signed this agreement on the final page, which is page 74. Is that your signature that appears there?
Yeah.
And in fact, each of the pages are initialed, aren't they, by you and by Mohammed?
Sure. Yes.
On page 60 at paragraph 1.1,
Yeah.
we see a definition of the first client, which was Britannia.
Mm-hmm.
The Britannia is described as the first client, and the referral agreement already anticipates that this is a referral that is being made from the claimant to your company. Do you agree with that?
True.
And the Britannia group, in fact, it's a group of companies, isn't it? It's 12 companies, a trust, and the UBO, Mr. Herrera Berlutini.
Yeah, this is the understanding.
And that's the group org chart that we see on this page 1, paragraph 1.1 in the definition section.
Mm-hmm.
So this is the Italian Venezuelan billionaire, Mr. Carrera.
Yeah, I have no idea about the micro details, but this is as per the agreement. This is what the details were available at that time, and this is what has been used.
And so this is potentially a very valuable and lucrative introduction that's being made to your company.
Yeah.
Now, the agreement is for a placement of a full-time compliance officer. And in relation to that, your company would be paid $15,000 US dollars per month. And you would pay to the claimant 6,000 of that 15,000.
So for this, the contract between the JPV and Wincore is about 15,000. It is the placement of one person, not two persons, just one person. $15,000. Sorry, so contract is for total contract is for $25,000 for placement of one person, for which the referral fees is mentioned here as 10,000.
Yes.
So for every $25,000, 10,000 is a referral fee.
So on page 63 of the bundle, if we look at paragraph 3.2, there is actually reference to two authorized control functions. And based on the invoice, it says that the first client, that's Britannia, would pay $15,000 per month for a full-time compliance officer. And $6,000 per month would be the fee sharing agreement.
Yeah. Sure.
And there would be a payment of $10,000 per month for the outsourcing of a full-time money laundering reporting officer with a fee share of $4,000. So that's where we get the $25,000 and the $10,000. Do you agree?
25,000 in total and 10,000 for referral.
Yes. Yes. So that's the referral fee of 10,000. And if we look at page 70 per month. Yes, thank you. If we look at page 70 of the agreement, sorry, page 70 of the bundle, which is page 11 and 12 of the agreement, and paragraph 10.1, the duration of this agreement was for 10 years. That is the referral agreement, not necessarily the agreement for the provision of the personnel. So the referral agreement has a life of 10 years. Do you agree with that?
This is written in the contract, yes.
Yes. And it would be renewable under 10.2 unless one party gives notice 30 days before its expiry.
Sure.
Now, in early 2022, you went to work directly for Britannia, didn't you?
Sorry, can you repeat the question, please?
Yes, in early 2022, you went to work directly for Britannia.
July 2022.
In July?
Yes.
So the agreement was signed, 19th of October 2021. So it's about 9 months in. You go to work for Britannia.
Yeah, so maybe I can, Millard, Your Honor, can I explain a little bit of background of this?
I think you're on mute.
You're not supposed to explain now.
Fine. Thank you, sir. Thank you, Millard.
If I can ask you to look at page 65 of the bundle, this is clause 3.5.4 of the contract. 3.5.4. Do you see there? It says no members, employees, or officers of the second party being the first defendant, your company, can be hired by the client, which is Britannia. Members, employees, officers, and associates of the second party, again, that's your company, will be prohibited from being employed directly by the client. So when you went to work for Britannia directly, that was contrary to this provision, wasn't it?
No, sorry, disagree with that, because this was a procedural one. From the day one, the individual allocated was supposed to work full-time with the client, with the Britannia. And that is how from the day one it has been registered with DFSA, registered with the IFC as a responsible person of the firm which hired us. It is applicable to the other members, of course, but even in this case, it is from the day one, it's a full-time inside.
Mr. Narayan, I'll suggest to you that isn't true, because if you go back to page 63 and look at paragraph 3.2 that we've just been looking at together, the reference there is for an invoice that's being sent to the first client. Now, you don't send an invoice if you're there as an employee. You just take a salary, you're on their payroll. So this is envisaging an outsourcing situation, isn't it? Where you're not an employee, you are outsourced to them.
Yes, you are right. It's an outsourcing arrangement by a firm which is a single person run entity. And in this situation, from the day one, the Britannia hired individual person as their in-house support, formalization of an outsourcing arrangement with the firm, because at that time, the firm did not exist. First, it has to be registered, then it had to get the license, then it get into this formal position.
On page 65, sorry to keep taking you back to between these two provisions, but under 3.54, no employees or officers. So as a director, you're an officer of your company, aren't you?
Right.
And it says that no officers or employees will be employed or hired directly by the client. That's exactly what you did, isn't it? You went to work for them directly. Yeah,
so this is an obligation, I understand, on the client, number one, because from the day one, when the referral happened, referral was for the hire of individual identified to be there full-time. It's a contract itself says full-time. Full-time, how do you work unless you are hired? The only difference is that invoicing of an outsourcing and non-outsourcing. But the whole thing was that this individual person has always been an insider working, and for that, the referral fee is being paid.
As a compliance officer, you'll understand that clause 3.54 is a contract term, and it's a contract that Britannia isn't a party to. So how can you say 3.54 applies to Britannia, to the client, but doesn't apply to your company.
So here the arrangement is such that from the day one, I'm trying to just reinforce the point. On the day one, this is full-time employment or full-time association or allocation of a person, individual, who is registered with the DFS as a regulatory person, who is responsible for that firm who is hired. It is almost like insider from the day one. However, you're right that it is the outsourcing arrangement in the beginning, and this continues.
Mr. Narayan, Mr. Yates tried to say, it can be officer, can be full-time employee, but it cannot be you or any employee of your company, because this would consider to be a breach. You could hire, you can find another officer for the company, for the client, but not yourself, not any member of any member of your company to be joined as direct employee of the client. This is what Mr. Yates trying to tell you, and why on earth you joined personally.
Yeah, so in the background, sir, Your Honor, in the background, it was a continuous conversation between the company, between the Wincore and the JPV, that we are getting into the license mode. We are getting the final license. We would like to have this person continue on the long-term basis rather than short-term basis. And then only we can continue about the situation is that this fellow has to move. This was being informed and confirmed and communicated between the Wincore and the Britannia, and informed and with my involvement. And I was congratulated by Wincore on this win, because it was supposed
to. This is confirmed between you and the client. We are asking about where the claimant consent.
Yeah, that's the claimant also was involved in confirming and with the consent of the Britannia, the ultimate hire.
That's wrong, isn't it, Mr. Narayan? Because you didn't tell the claimant, you didn't tell Mohammed that you'd moved.
So the point is, it is based on the conversation first between Britannia and Wincore, Mr. Rahali. And then Mr. Rahali came to the office and confirmed to us and congratulated to me in the office, saying that very good, this is going to be a long-term relationship now.
Good. Okay. Well, this isn't in your witness statement, is it? Nowhere in your witness statement do you talk about Mr. Rahali congratulating you and coming to the office.
I've not mentioned that. Yes.
No. And if we look at page 84, page 84 is a copy of some WhatsApp messages that are exchanged between yourself and Mr. Rahali on the 27th of July 2022. And the first thing that you say is, I wanted to speak to you earlier, but due to paucity of time could not. As you know, I moved to Britannia payroll due to pressure and Dan's expectation management. So you're acknowledging there, aren't you, that you hadn't told Mohammed either in the lead up to it or when it happened?
It's not, there are two different contexts here, Mr. Shan. Here, the context is different. Here we are talking about renegotiating the fees given the circumstances change. That's the background of this conversation. Okay.
Well, what you say here is, as the first thing you're talking about is your move. As you know, I had to move to BGSML.
As you're aware or as you know.
That means they're in knowledge. Let me finish. That I had to move to BGSML due to pressure. This is the thing that you haven't told him about because of lack of time, isn't it?
If you read that, I read it like this. As you know, I had to move. As you know, that means he was already aware, informed, informo, whatever.
Now, you said you moved in July, but here this third paragraph says you moved in May.
Yeah,
that's
so
2 months
May
earlier.
was right. So the last invoice from the JPV to Britannia was for month of June, which was paid in July.
When did you move? When did you move?
Yeah,
July or May?
July as an employee-employer relationship.
So when you say in May it moved, that's wrong, is it?
May is the date when the kickoff between their internal discussion from London office and other offices, whether, how, etc., etc. So it's a May the kickoff.
And you moved voluntarily, didn't you?
Yeah, when you say move voluntarily, it was at the request of the client. Otherwise, this contract would have discontinued.
But you say there in the fourth paragraph, I had a choice to say no. So you could have said no, but you chose to go there.
Yeah, but no here means, I'm just trying to explain, no here means that is continuation of service because that is what they wanted.
So that might have been the implications of no, but that's not what no means, is it? Let's not redefine what no means. You could have said no.
Yeah. So let me, maybe I would be brief, but if I can add some lines here, is that when the request
if
came...
you just ask my questions, you've had the opportunity with respect, Mr. Narayan, to put your story into your witness evidence. So I now get a short time to ask you questions. If it's helpful for you to explain, and as a result of those questions, then please do so. But it's not a platform for you to tell us your version of events. So if you could just focus on the questions, then what I'd suggest is that you were bypassing the contract by going to work for Britannia directly, weren't you? This was outside of the referral agreement.
It was in conversation and what do you call, in knowledge of all three parties involved.
You want to renegotiate the fees that were payable to the claimant, and we see that later on the same page, at page 84, don't we? You wanted to change the arrangement from the 10,000 out of 25 to 5,000 out of 25. You say to the bottom third of that page, you're saying you have to manage two extremes, and you suggest a split of 60-40 rather than the 80-20, which was the previous arrangement. Is that right? Is that what you're saying there?
Yeah, previous arrangement was 60-40, which
Instead
is
of 60,
25,000 out of 25,000, 15,000 for me, 10,000 for referral.
And now you're saying 80-20. You're suggesting 80-20.
That's where initial suggestion.
And you say that no invoice can be raised on JPV, that's first defendant, since no revenue is coming there. And I can't pay directly from my personal account due to DFSA governance issues. And I can do payment in cash without any VAT billing. So are you suggesting that you avoid paying VAT and just give something in cash? That's what you say. I can do a payment in cash. So you're suggesting some cash off the books record payment without VAT for the same agreement. You're going to switch it completely and avoid paying tax.
I don't know whether there is a context to it or there is a relevance to this question here in this case we are talking about.
Well, as a compliance officer, you shouldn't be looking at ways of avoiding payment of VAT, should you?
Yeah, so here the relevance is that when we are talking about a lot of things on the conversation, we are talking about how to deal with the situation. And then we are talking about that first, the ratio. That is where the focus was. Here, there are other context, but which is obviously I'm not going to put here, why it was being discussed like that. But obviously, there is no intention of any violation, etc.
On page 85, over the page, this is Mr. Rahali's response. He says, an agreement cannot be changed amongst gentlemen. We agreed the current sharing, whilst he didn't want to pay you a salary above 15. We made it 25. Okay, so the suggestion there is that you reached an agreement through 25k as your salary or as the monthly payment as a result of the claimant's involvement. And Mr. Rahali here is saying, no, I don't agree to the change and you should continue to pay the full amount. Is that a fair summary of what's being said here? The claimant disagreed.
Yeah, because it's a concocted or abridged conversation listed here. The discussion continued and it concluded in the different agreement. Both of parties agreed on a different number, but here it is not the full conversation.
Right, so there's no agreement reached here.
Yeah,
and this is again on the 25th. There's a response from you again saying nothing has changed, parameters are the same. we have to revise these ratios to continue. Now, what did you mean by that? We have to revise these ratios to continue. Does that mean that you were only prepared to continue if there was a change in the payment?
Yes, because the conditions and the expectation of the clients were known to be 100% different from what it was originally contemplated. That means the individual's cost of employment will change, and that is where negotiation happened. That we have to work on, because this is now a long-term contract, not expected to be originally short-term contract.
But you continued to be paid $25,000, didn't you, per month?
Yeah, I'm saying the work, because just a background, if I can say, that we, as a full-time compliance officer, we are not required to be necessary to be in the office. We can work from anywhere and we can take any other role. I'm a consultant. However, when the client expectation was that you got to be in the office, now we have an office, you have a license, you have to be full-time in the office, leaving everything outside. That is where the terms and the situations changed.
So this is you wanting to change the agreement?
Yes, based on the situations and the context.
At the bottom of page 85, there's a further response from Mohammed. Dear JP, I do not respect changes in commitment. He says, you are a man of experience. All that was occurring was foreseeable.
Yeah, but that's a continuous conversation in between. I mean, it continued.
And he says that at page 86, we will continue to issue invoices to your company to have our fees paid. And your response is, I would again request you to change the agreement as I suggest with immediate effect. So there's no agreement being reached here.
No, the agreement was reached.
For a change, and he's saying no.
Yeah. So in these documents, there's a truncated conversation posted here. It did reached, and that is why we agreed to invoice differently in July.
But why haven't you provided it? If you say there's a continuation of this conversation, it's not in evidence. You haven't provided this.
Yeah.
Why not?
Yeah, the point is that the overriding this discussion of potential changes which are being talked about, when Mr. Rahali is talking about that, can we make it 70-30 from a period, whatever. And then we concluded saying that, okay, this is the amount which we are going to charge. And then the next invoice was raised with a revised amount.
Well, Mr. Rahali and the claimant say that that's not the case. But if we go on from this conversation, up until November 2023, you paid invoices, didn't you?
Which page we're referring to, I'm sorry?
Well, you say that you paid invoices up to November 2023 in paragraph 17 of your witness statement.
Okay.
If you look at your witness statement, paragraph 16 is on page 53 of the bundle. You say that all invoices up to November 23 were settled, and you say as per the revised rates.
Right.
Yeah. And you say slightly earlier, that paragraph 10, that even after I joined the first client, the claimant continued to receive its referral fees until November 2023. So what you're saying is that you continued to pay them.
Correct.
Did you pay them personally, or did the company pay them?
The company account got paid.
Sorry?
Company paid it because invoice was raised on the company. When the invoice is raised on company, the company has to pay it.
Did your company have any other clients?
Yes.
So your company had sufficient cash flow and bank accounts to make these payments?
Sure.
Did you put part of your salary into the company to allow it to make those payments?
No, it was already there funded, and it is in the the partners fund movement.
If you look at page 108 of the bundle, please, you'll see this is a final account, or an account statement, running account statement from the claimant. And it's difficult to see because it's actually the wrong way around, but in respect of the payments up to November 2023, you'll be aware that there's a suggestion that there were two payments that were not made. June 2022, which is payment 8, and July 2023, which is payment 21. The first one's for 38,561 dirhams, and the second's for 26,992.88, again dirhams. So you're aware that the claimant says that these invoices were not paid?
The procedure we have followed is that every invoice which has been raised by them has been paid on first come, first served basis. So if your invoice is July, you raise it in early August, it is paid in August. You raise for August in early September, it's paid in September. And that is how the invoices have come and have been paid. And in November and December, when we had the discussion, there was no mention of anything in the past pending. November 2023, which is almost 1.5 years in the contract.
This was provided with the particulars of claim.
Yeah, this is one-sided statement which came in from them as part of the legal process.
Yes. Now, why haven't you provided bank transfers proving that you did make these disputed payments?
Because these invoices have not come in terms of why and what for they have been raised. For what?
That doesn't answer the question. If you have bank account, your company has a bank account, does it?
Yes.
And you have bank statements that come to you from the bank.
Yes.
And so there would be bank statements that show these two payments being made.
Last payment, so because these are not invoices, I said the invoices are paid on when they are issued to us. If there was anything pending, if there is anything pending, it is a part of the reconciliation.
Could you answer the question, please, that there must be bank statements that show these two payments being made?
Yeah, so when I said these invoices, I don't recognize.
Yes, it's just yes or no. Are there bank statements
I don't recognize these invoices. I'm saying that.
But these amounts that are said not to be made, there must be bank statements showing that they were.
It's not that. The invoices are raised and paid, and it is through email. Invoices are not by hand. So any invoice is received to us in the email, it is paid through bank transfer.
So you haven't provided the bank statements showing these transfers, have you?
They have to give first the invoice to me.
So you're saying that these payments might not have been made because you're saying you didn't have an invoice for them?
First, the invoice is not received. For me, anything is due once the invoice is received. And if it is not received, number one. And number two, there was a statement of account from their side fully clearing that as in end of July, end of 2022 or later mid 2022, SOAs from their side, 0 pending, nothing is pending. And now they are claiming about May 2022, which doesn't make sense.
Mr. Narayan, this schedule here lists only 26 payments. It wouldn't be a difficult exercise for you to provide bank statements showing that you made 26 payments, would it?
Yeah, point is that when the statement comes in, we sit down together and find what is missing, what is not missing. Please note, the last payment I made to the firm was on December 7, 2023. So December 7, 2023 is the payment made, 26,992.88 dirham, which is $7,000 equivalent.
So
that's the last payment in December.
So you haven't provided any evidence to this court to show that you have paid these amounts, even though you could have provided statements?
These invoices have never been sent to us before. And now it is a part of the reconciliation to say if there is anything pending. And it cannot be in isolation from the distance.
If we please look at page 103 of the bundle, this is a later series of WhatsApp messages coming from March 2024.
Yes, please bear with me.
Do you have that? That's page 103.
Yeah.
And here, Mr. Rahali, at the third message at the timestamp 12:13 is saying to you, is asking you, how many outstanding payments did you find in total? And you're saying, and this is in March 2024, so 4 months after the time period we're speaking about. You say invoices November, December, January, and February, 2 for February. So that's 5. So you're identifying 5 invoices that haven't been paid.
Yeah. So we are negotiating for the revised terms of the contract in after the end of 2 years of the contract. So end of October, we started talking about that for November, December onwards, we have to have a different arrangement. And for that, the conversation continued. We were requested that please pay for November and December. We'll revise the rates for next month. That is where all this conversion, and then this detailed story happened where the reconciliation started.
Mr. Narayan, if you just go down a few lines, Mr. Rahali is asking you to confirm 5 payments are outstanding, and you say yes. And then he says 5 are missing, including the month of February. He asks you to settle them. And then later at timestamp 12:30, pay the outstanding bills. And you are saying in the line before that we need to agree on a way forward. Your response at timestamp 12:30 is there is no issue. Let's meet today, finish all discussion, same time I would clear payments. So you are accepting that those payments are outstanding.
What we are agreeing is that please sit down, let's clear what is the confusion on the invoice pending. That's the purpose.
I will settle all of them.
Yeah, whatever is pending, let's clear and reconcile.
This is what you say on timestamp 12:31. I will settle all of them rather than in pieces.
Yes.
You haven't made any payments towards these outstanding invoices, have you?
Yeah, because
is that yes or no? Is that yes or no?
No, because this is the executed amount. I mean, we have agreed, we have an invoice coming from them in January for the different amount, $5,000. And then again, they're changing the invoices in $7,000 and claiming $3,000 for everything more. There is a big difference in terms of what we're talking about. And then it gets into a legal notice.
Do you remember sending your own statement of account in relation to this?
Yeah, that is in isolation what we are doing. Yes.
Yes. And in that statement of account, the full amounts were there, weren't they? The full amounts of the invoices.
Yeah, as sent by them. We are talking about difference between the two people talking about that what is pending, what is not pending. But in the context of the new conversation which have initiated, and there was an invoice issued in January 2024 for 5,000 and odd number that is not attached by the claimant, which was the amount agreed about the revision from January onwards.
So did you refuse to pay because the claimant wouldn't agree to reduce the invoice amount?
No, the refusal to pay was to claim 2 pending from the past invoices, which were never issued to us. And that is where the disagreement started. And then it was already agreed that from January onwards, the revised rates will be applicable. And that's why we had to sit down and reconcile and talk.
Could we look at page 53 of the bundle? Because this is where in the witness statement at paragraph 15, you say that you proposed 2 reductions.
Yeah.
And in late 23, you say you proposed 4,000 and the claimant said 5,000. None of this is recorded anywhere, is it?
Yeah, it is recorded by the revised invoice by them sent in January.
There's no revision to the agreement saying that we will hereby change the agreement and the new rate will be $5,000 per month.
Yeah, it is the same context as we go to from 10,000 to 7,000 in July 2022. It's the same story. We are 2 professionals talking a lot of things on WhatsApp and informal conversation and leaving it there. We are individual driven entities.
Isn't it the case that the claimant was just giving you more time to pay by issuing reduced invoices?
No, it was not the more time. Absolutely not. And the reduced invoices continued from July 2022 till November 2023. The suite more than 1.5 years, or almost 1.5 years.
But you're aware, aren't you, that under the agreement, it said that if there was to be any change to the referral agreement, it had to be in writing.
Yeah, and there were a lot of conversation in writing in terms of email and revised invoices received.
But you
without
haven't
any
provided,
mention that it is partial, non-partial, it's a full. It says for this month, for this dollar, at this rate, total amount, VAT amount, total paid.
so your case is that the only evidence you have to show that the amount was reduced from 10,000 to 7,000 is the reduced invoices.
Yes, from July 2022.
There were no invoices that were ever raised for $5,000 per month, were there?
There was one invoice raised for $5,000 plus in January 2024.
Wasn't that invoice made contingent upon a written agreement being in place?
Yeah, there is nothing mentioned anywhere. And it was not the case with the $7,000. It is not the case with this.
And do you remember having an email exchange? If we look at page 94 of the bundle, there aren't any email exchanges between you and Mr. Rahali, but there are one or two emails with you, between you and, is it Dilu? If we look at the bottom of page 94, Dilu was writing to you in January 2024, gentle reminder for the outstanding payment. We request you to settle the outstanding payment for the month of December. As mentioned earlier, any changes regarding the invoice will be in effect from January 2024. So the January 2024 payment upon the requested document submission and the discussion upon the submission of requested contract and settlement of pending invoices. So what this is saying is pay the outstanding invoices up to January 2024, and then we'll have a revised contract.
Yeah, what it's saying is, as I said, the background, that contract completed 2 years in October, and we wanted to change the context from November onwards. They agreed that we please pay the November and we'll talk about in December. And now they came back to December, we'll talk about in January. And that is why everything, if you see this mail, it says everything is paid up to December and last invoice pending is only December. So later on, they came back with the story that there are other invoices pending from 22, 23 and all that, which was a later thought. But if you see this mail, which is January 15, 2024, it clearly says last month, December invoice pending, nothing else.
Well, you say that, but let's not switch around and use the evidence to our convenience, please. You've just accepted that in your email, your WhatsApp messages, that you accepted there were 5 invoices that were outstanding. That included October, November, December.
I think I've explained what it means. I've not said yes and no, because it is subject to recon.
So there were 5 invoices that were outstanding. There was a suggestion that there might be a renegotiation of rates from January 2024 if you settled the outstanding ones, but you never settled the outstanding invoices, and there was never any amended agreement, was there?
Yeah. So same evidence which you're referring is 15 January 2024, 528, page 94. It very clearly communicates from their staff or from Wincore that for month of December, please settle. They're not saying there is 1 or 2 or 3 or 4, just one invoice they are saying pending. In January, this is January, when we already agreed that the new rates will apply.
You're ignoring the document we've just looked at. You haven't forgotten the WhatsApp message we just looked at where you agreed there were 5 outstanding invoices, have you?
What it means is somebody is saying there are 5 differences. We are saying, as per you, this is 5 pending. Let's sit down and work it out. What is it? That's where it is required.
And you have not paid anything beyond November, have you?
Last payment I made was on 7 December 2023.
And it relates to November 2023.
Last invoice, which was agreed that please pay November and we talk about in December and fix it. And then December, they are saying please pay December. So that is what I'm saying. Let's clear it and complete it.
Now, if you look at the last sentence in your witness statement, this is paragraph 22, which I took you to earlier.
Yeah.
So paragraph 22, you talk about the claimant's attempt to enforce an illegal and unfair agreement. Now, we know you're not saying it's illegal anymore. You haven't said why it's unfair. So if it's neither illegal nor it's unfair, your payments under the agreement are still payable, aren't they?
Yeah, as I said, if you go back to again page 94, we are talking about everything has been paid except the last month they are talking about that please pay December. So normally the December invoice is paid in January. So there is nothing called carry forward effect on my any outstanding statements till they got into further legal process and reconciliation and one-sided communication that I have this much pending and things like that. And I was still trying to sort it out.
You haven't made any payments since then.
December 7 was the last payment.
This agreement is still in existence, isn't it?
Yeah, disagreement in existence because we went to the legal notice, we claiming too much amount, we are claiming different amount, disagreed amount, exaggerated things. So I can't be into that situation to get into the payment mode. So
on so you have no basis for ending these these payments in November 2023, December 2023. They should have continued into 2024. Why didn't you make any payments in 2024?
Yeah, so as I said, I'll try to repeat, but unfortunately at the cost of the other, that at 23 November, we paid the last invoice in December. Come December invoice to be paid in January. That is the time we said, please, let's change. And we are talking about the change amount. And then we get the invoice, which is in January for $5,000 after the discussion. And then very quietly, as a part of the legal strategy, somebody come back and says, hey, let's claim everything backward. Go back to the zero. That is where the disagreement happened.
You were working at Britannia until February 2025, weren't you?
Yes.
And so the payments under the contract would run through until February 2025. If there were no changes agreed, if you hadn't made any changes, the contract would go at least until February 2025.
Yeah, so the invoice says in January, only one invoice was pending, which was December. And then suddenly after the conversation, we got another invoice, which is January for $5,000 and odd. And then suddenly in next 2-3 days, probably at the advice of the legal team and whatever, I got 4-5 invoices, one immediately in the same month, in the similar dates, saying that please pay all this. And this become very confusing story. And because of that, and after that, just to add here, after that, there has been no invoice. And we are into legal.
Mr. Narayan,
got legal
Mr. Narayan, to understand you, I think you just said, I think a minute ago, is that true? Until December 2024, no agreement is reached. Is that right?
December 2023, sir, my lord.
2023, yeah. No. So
we are in discussion.
Discussion is then, no agreement reached.
And then in January, a new revised invoice is sent to us for $5,000 and odd.
Because I might have heard you saying in July, you said when you was showed the WhatsApp discussion, you said we're already in agreement, but now you said until December there's no agreement.
In July, my lord, Your Honor, in July 2022, there was a revision of the amount from $10,000 to $7,000 per month as a referral fee. And then it continued for almost 16 months up to the end of October, which is completion of 2 years into this contract. And that is the time I asked Mr. Rahali to renegotiate given the circumstances, and it is a full-time contract. And then they said, please pay November and we'll settle it in December and January. And then in January, after the discussion, they use the new invoice, which is around $5,000. But then after the legal discussion, it all changed.
So the problem is related to the second amendment to the fees that from 7 to 5, not from 10 to 7.
Correct.
I see. I beg your pardon, Mr. Yates, I just interrupted you. I just wanted to understand things.
And of course, there's just one more topic I want to discuss with you. If we look at, please, at page 71 of the bundle, you'll see that in the agreement,
Just give a
the
second,
referral
please.
agreement, page 71. So this is the referral agreement at paragraph 11.5.
Yep.
Included in the agreement was a liquidated damages clause, what we call liquidated damages clause. And it says that in the event of a breach of the terms and conditions stipulated in this agreement, by the second party, that's first defendant. Second party shall pay to the first party the amount of 500,000 dirhams as compensation for the breach. So you agreed to that term in the agreement. You signed the agreement and you've initialed that page.
It's in the agreement, yes.
Yes. And so if
it's in the agreement, it's written in the clause.
It's written in the clause, yes. And you're moving across to work for Britannia was a breach of the referral agreement, wasn't it?
No, it was with the consent of all three parties involved, so it can't be breached at all. And then we agreed on the revised rates, and we continue to be paid on the revised rates, despite being informed.
Please, you moved in May. You say that the agreement on the
July.
In the WhatsApp message, you say May.
May, the trigger of the conversation.
And then in July, you say that you moved and everybody agreed and you started paying the reduced amount.
Yes, that is one. And second, in July, up to end of June, it was invoice between JPV and Britannia. And from July, it became the transfer of salary.
As a compliance professional, in this case, there are many suggested changes to the agreement that we don't see in writing. Shouldn't you have made sure that these changes were in writing?
I was overconfident of my relationship with Mr. Ali, which went on before this contract. We have done many projects before and we understood each other and we communicated each other nicely. A lot of times he's traveling a lot, not available most of the time. We always converse on WhatsApp, and then eventually this fell off. That's where the problem is. Otherwise, we have done things before and after, all on WhatsApp, all on this kind of a base.
But you agree in the WhatsApp messages we've shown you that there doesn't appear to be agreement because you're suggesting one thing and he's suggesting something else.
Yeah, because it's not the chat mentioned here or attached.
And you haven't provided the full version for the court to see.
Yeah, unfortunately for me, I had changed the phone around that time, and then there was some issue with that, and I lost some of the data. But the proof of the putting in the eating, from that month onward, the amount changed, invoices came without any mention of any issue with that reward change for 16 months.
Before we get on to pudding, can we consider whether you put in your witness statement anything about your lost phone that doesn't have the messages that confirm?
It's not mentioned. I thought it was not necessary.
I see. Thank you, Mr. Narayan. I don't have any more questions.
Thank you very much.
Thank you. Thank you very much, Mr. Yates. Mr. Chaudhary, if you have any recap with the witness, or you have any?
Your Excellency, with your leave, I just wanted to ask just a very few number of questions, if you will permit me.
Please.
Thank you. Mr. Narayan, in the bundle, could you turn to page 108? This is an Excel sheet. I think, Your Excellency, on our monitors, it's appearing in a wrong way round. It is possible to rotate the document using the PDF Adobe software so that the numbers become readable. If Your Excellency would just do that. I've managed to rotate it.
I'm fine. I can follow.
Okay. Sure. Fine. Thank you, Your Excellency. Mr. Narayan, if you could turn to that Excel sheet on page 108, I think you have the hard copy, so you should be able to just see it clearly enough. Can you tell Your Excellency, I think you've touched upon this during the cross-examination by Mr. Yates, but could you tell Your Excellency that if you see line item 10, which is the far left column on that Excel sheet, and then you go across to the fourth column. The fourth column has the numbers 07 star 2022.
Right.
Do you see that?
Yes.
Does that signify that entry is referring to services rendered to Britannia for the month of July 2022?
That's true.
Okay. If you now go another column to the right, sorry, another 2 columns to the right, the amount is shown as AED 26992.88. Is that correct?
Yes.
And applying the fixed exchange rate between AED and USD,
This
would that
$7,000.
calculate to $7,000?
Yeah.
Yes. Now, you can see that in multiple invoices appearing under that, so from line item 10 onwards, all the way to line item 26, except a line item 21, the AED number is precisely, well, it's more or less 26,992 dirhams. Do you see that?
Yes.
So is it fair to say that for each of those months when you were providing the service to Britannia, the amount that you were being invoiced was $7,000
That's true.
equivalent, and you were making a payment of that in the usual way?
That's absolutely.
Now, can I take you to another part of that bundle, please? Let me just give me a second. I have to reorient the PDF document on my system. There is and this Excel sheet I submit is part of the claimant's evidence, Your Excellency. So this is this document is coming from the claimant entity. Mr. Narayan, could you please turn to page 75 of the same bundle?
$75. Yeah. That's exhibit.
Yes, that's just a cover sheet for the Exhibit B. This Exhibit B was also part of the claimant's submissions.
Right.
Right. Now, if you turn to the following page, page 76.
Yeah.
You see that is an invoice from the claimant to your company, defendant number 1. You will see on the right-hand part of the document, it says invoice date. Do you see that?
Yeah.
It says 2nd June 2022.
Right.
In the item and description heading, which is, Your Excellency, it's appearing up under a black bar. Mr. Narayan, can you see it says invoice for the month of May 2022?
Correct.
And that amount, of course, applying the conversion rate of 3.6725 dirhams to a dollar.
It's $10,000.
It's equivalent of $10,000. Of course, it says so as well in the invoice. Now, this was for services rendered in May 2022. And that is before, when you say parties had agreed to the revision of the commission payable from you to the claimant. Is that correct?
Right.
Now, can you come to the following page, please? Page 77.
Yeah.
Now, these, this page, as well as a few other pages, are invoices of respective months after the commission amounts were changed.
Correct.
Between the parties. Can you see page 77? The invoice date says 10th of July 2023. Right. And under item and description, it says invoice for the month of June 2023.
Yes.
The amount here is the equivalent of, it says 25,
$7,000.
707.50. And then, of course, you're adding the VAT and it comes to a larger amount. That 25,707 is equivalent of how many dollars?
$7,000.
And when you receive these invoices, did you receive any other communication from the claimant entity to say that this is a 7,000 is only part payment?
No, no other
or
communication.
a larger amount that is otherwise due from you to them?
No,
Can you please come to
Mr. Chaudhary, I mean, let
Yes,
me
yes, Your
clarify
Excellency.
this while we're in the same page. This is page 77. Well, I can see, although the amount to transfer is 25,700, which is maybe equivalent to 7,000, but then the note next to the number 1 says invoice for the month of June, management consultation services, $10,000. It says, then I think it's mentioning the exchange rate, which is 3.67. You see that?
Yeah.
Yes, Your
Yeah.
Excellency.
Well, if you just have your witness to explain the difference between the note in the left side and the amount transfer into the right side.
Your Honor, my understanding is that because there was probably a change from 10,000, which has been going on for a long time, for some time, and then change to the amount. They have the clerical staff in the office. They made some typo errors in this. And then after this, every invoice was correct, $7,000 from that month onwards. So it is first month after for the new invoicing. It might be a typo because after that it continued for the 16 months up to November 2023, the same amount.
Yeah, I noticed other invoices had mentioned 7,000, but not this one. Yeah.
Yeah,
You said
so it's a typo of the first month error. But the amount was paid as invoiced and it was received without any objection.
Thank you.
I may have just one further question, Your Excellency.
Yes.
Just a minute. Thank you. Could you turn to page 92 of the bundle?
Yes, please.
This is an invoice that is dated 17th of January 2024, as you can see. In this invoice, the management consultancy services, the rate being quoted is 20,000 dirhams.
Yes.
Which applying the legal conversion rate comes to approximately $5,445 US. Can you explain to His Excellency why this represents, again, a different amount to the invoices that we have been seeing just now, which was for $7,000?
Right. So based on the conversation and discussion and follow-ups we are having together on the revised rates, it was agreed that they will invoice us $5,000 now onwards instead of $7,000. And that is how this invoice immediately after that meeting came to me next day. Okay, and this is around 5,000 and they rounded up in AED. It's around 5,400 or something.
Yes, thank you. But can you explain why it is not a 5,000? Why is it, again, a different amount?
Yeah, it is. Only they have to explain that why they wanted to still increase it from 5,000 to 5,400. It's up to them to explain. But this was received to us.
Right. Your Excellency, I have nothing else to ask unless Your Excellency has anything to ask of the witness.
No. I just one more clarification. This is tax invoices. This is represent the document issued by Wincore itself. So this document comes from, because you can see the head letters.
Right.
Yes, Your Excellency. Yes.
Yeah, thank you.
It's a valid invoice.
Yes. That's all. Thank you very much. Thank you, Mr. Narayan.
Thank you. Thank you, Your Honor.
Thank you. Well, I think it's maybe time to take a short break before we start our closing submission. Is it okay if we come back at 1 o'clock sharp Dubai time, like 50 minutes from now? Should that be fine with you?
Yes. Yes, Your Honor.
Yes, and we do it in the usual order, the claimant and then the defendant.
Yes, thank you.
Thank you very much.
Yes,
See you
thank
then. Yeah. Good afternoon, counsels.
Good afternoon, Your Excellency.
Good afternoon.
Suriyat, you ready?
Yes, Sean.
Please. You may please the court.
Thank you. Your Honour, what started as a relatively simple case with very few issues seems to have narrowed into one with even fewer. So there's no longer any question as to whether or not this agreement, the underlying referral agreement, was illegal. And so the remaining issues are really just whether or not there was a breach, whether there were any variations, and whether there are any outstanding payments. So those are the three real issues that are outstanding. On the first one, whether there was a breach, we say that there is a breach or a non-performance because even on the defendant's case, that these variations were agreed upon from $10,000 per month down to $7,000 and then down to $5,000. They haven't paid the invoice. They haven't made any payments since December 2023, even on their own account, and yet payments are outstanding. So that is itself a breach. And that breach goes to whether or not liquidated damages are recoverable and should be awarded to the claimant. So we say there's no real issue there. There can't be. However, the court is aware that the claimant's suggestion is not just that there was a breach in relation to the non-payment of due invoices, but also in JP's, Mr. Narayan's transfer across to Britannia to be engaged directly. We say that was a breach. The defendant's witness, the second defendant, accepted that unless it can be established that there was an agreement to vary, that would be a breach. He accepted that he wouldn't be able to do that unless it was agreed. He says it was agreed. He says that that agreement was reached in July 2023, around the same time as when there was also an agreement, he says, to reduce the invoice amounts for 10,000 down to 7. Now, when it comes to the evidence that you've heard, you have only heard evidence from Mr. Narayan, and we say that that evidence is unsatisfactory for reasons that I will come on to. But there is also the evidence of the documents. And so in relation to the documents on whether there was a breach and whether there was an agreement, there isn't anything specifically that says we agree, we the claimant agree that you can go and work for Britannia directly. The defendants effectively ask you to infer that from the fact that the claimant continued to issue invoices and that those invoices were paid. They also ask you to infer that there was an agreement to a reduced amount for the same reasons, that the invoices were issued in the sum of $7,000 and that they were paid in the sum of $7,000. They say that's an agreement. But also on the documents, you have contrary evidence that has to be weighed up against that, because there are other possibilities. And the claimant's case is that there wasn't an agreement to vary the amount that was due. There was just a deferral of the balance amount. That's what the pleaded case says, and that's what the claimant was going to tell you, that the deduction was because of cash flow, so pay 7 instead of 10, you can pay the rest later. Supporting that position is the fact that when the legal notice eventually came, when payment stopped and the legal notice was sent, that was for the full amount. It wasn't for the discounted amount. It wasn't for the non-payment of $5,000 invoices or $7,000 invoices. It was for the full amount. The second piece of evidence that supports the claimant's case is the WhatsApp messages, because the WhatsApp messages, whatever they discuss, they do not demonstrate any agreement being reached. All they show is that the defendant, second defendant, was asking for a reduced amount, for an amount that he said he thought was fair and that had to change, and how the agreement couldn't proceed on the old basis. So that's what you have, his proposals. But within those same chats, you do not have any resolution. You have a response from Mr. Rahali saying, no, I don't agree with that, and you should stick by your original agreement. Now, today, for the first time, and this comes down to credibility, there's been the suggestion from Mr. Narayan that these chats are not complete, that there's some other bits that are missing. When asked why he didn't provide these missing parts of the chat, which one would have thought would have been essential for him to prove that there was an agreement, he gave two responses. One, that he didn't think it was relevant, and second, that he lost his phone. And the chats were then lost. So for the first time, off the cuff, not in his witness statement, this is the answer that the court is expected to asked to accept by the defendant. And we say you should not accept that. The other reason why the invoices themselves are not sufficient evidence of an agreement to a reduced amount is that the covering email that we've seen in page 94 of the bundle, where the $5,000 invoice is sent, specifically says that this invoice is being issued on the basis that you pay the outstanding one, which was never paid, and that there's a new contract that's signed. We await the new contract that records the variation, and those things are not there. This is the reason why agreements contain provisions saying that if there's to be any variation, it must be in writing. And we have such an agreement in this case. And we say that that's where the court can rest its decision. These are business people. They've entered into an agreement. It's not going to win any prizes for its clarity, this agreement, but it's one that they both signed. They initialed every page, and they included that provision that any agreement to vary is to be in writing. And the defendant is a compliance officer. He knows the importance, or should know the importance, of putting things in writing. So the evidence is, we say, against any variation having taken place. It was certainly discussed, and there are proposals and counter proposals, but absent any variation in writing, there isn't any. And any invoice that was issued in a reduced amount, the court is able to infer was a concession for a reduced payment because the defendant was having difficulty paying the full amount. The other reason why credibility is something which we say cannot attach to Mr. Narayan's evidence is that on this issue of the two missing payments, his evidence was entirely unsatisfactory. There are not many payments that have been made, and in that schedule that Your Honour was taken to, there are only 12. The limited, sorry, there's 26. There's 26 payments in total, but 2 of them, it suggested, were not paid. And the witness accepted that that company has bank accounts. He accepted that bank statements were received, and it would, I suggested to him, have been very easy for him to produce the bank statements showing that the payments have been made. Easy, just 2 payments. That's all he has to prove. And they have not been produced. So in circumstances where, from the beginning, from the particulars of the claim, one of the issues has been these 2 payments have not been made, it was incumbent upon the defendant to provide these bank statements to prove it. And he hasn't bothered to do that. The evidence we have now is that he didn't think it was important, and something about not having received invoices. So if they haven't received invoices, I can't pay them. But we're hearing this for the first time. And we're hearing this for the first time because for the longest of times, up until yesterday, when I'd finished my opening, the position had been maintained that this was an illegal agreement. That was the main defence. So we've wasted a lot of costs and effort and time on anticipating that being the main defence when it could have just been ignored. But no evidence has been provided to show that these missing payments were made. No evidence has been provided to show that there was a variation, and there's an equal amount of evidence from the claimant side to show that there was no variation. So on the issue of credibility, we say that you can rely on the documents and put the defendant to prove that their case is correct and established. Of course, you haven't had the benefit of hearing from the claimant's witness, but that be as it is. The other issue that you are to determine is whether, if there's a breach, the liquidated damages clause applies. And there was no challenge, there has been no challenge to the amount of that liquidated damages being unreasonable. It was explained to the court that this is a 10-year agreement. And whilst Mr. Narayan in his statement says that at one point he effectively says, well, they weren't doing anything for the money. The claimant was being paid for nothing. But this was a very valuable introduction that was made to a very large company and potentially very lucrative. And in fact, the second defendant was employed until February 2024 and received this $25,000 per month right from October 2021. So it certainly had a benefit from it. It's valuable to him. And when the parties agree upon the liquidated damages amount in the event of a breach, it's something that should be enforced. The court's familiar with the Panther decision and from the Court of Appeal, and these must be strictly applied when parties have freely and commercially agreed to them. So those are the points that I'd make on behalf of the claimant, because the amounts are, the issues are very narrow, but to confirm the amounts that the claimant claims, they fall into 4 categories effectively. And the first is the invoiced amount that's not been paid. So that's the amount actually on the invoice, not reflecting the fact that these may be discounted invoices. And that amount is in dirhams 200,518.53. The second category of claim is the uninvoiced amounts. And what that represents is the shortfall between the 10,000 and the 7. So it's 3,000 per month. Every month when there was an invoice issued for 7,000, we say that it should have been 10,000. This was a discount that was being given. And that runs from July 2022 to April 2024. And the monthly amount there is actually 11,568.37 per month. And the total amount is in dirhams 254,504.14. The third category that's claimed is the uninvoiced amount following on from that date, because this was a 10-year agreement and the defendant has accepted that it's still running. But in this case, the claimant has limited its claim up to the point when the second defendant left Britannia, and Britannia subsequently closed, it shut down. So he came off the DFSA website where it lists the compliance personnel associated with the company. He came off there in around February 2025. So we say up until that point, he accepted that's when he was employed until he continued to get that 100,000 dirhams, whatever it was, $25,000. Yes, so he continued to get that. So we say that runs to then. But that would be at the full amount on the basis that we say there was never any variation to the contractual amount. And that comes to AED 386,512.50. Then the fourth and final category that's claimed is for the contractual liquidated damages amount. We say that that's a fair amount, reasonable amount according to Article 122 of the DIFC Contracts Law. And even though there's no need to establish that this amount of loss has actually been sustained by the claimant, so it doesn't have to revert to actual loss, we say given the size and value of this group that was introduced, a provision such as this, calling for liquidated damage, isn't unreasonable. And the total amount of those 4 claims comes to 1,341,535.17. Again, that's a dirham amount. So unless, Your Honour, I can assist you further in any particular aspect, those are my submissions on behalf of the claimant.
Well, thank you, Mr. Yates, for the enlightenment. But if I may ask you, so the 3 categories of non-payment related to either the invoiced bills or non-invoiced bills, or even the shortfall, made under the assumption that all the relevant and material time, the fees payable to the claimant was $10,000 a month, and there is no evidence that this amount being contractually agreeable. Is that right?
Yes, that there's no contractual agreement for a reduction. Yes, but of course, if Your Honour found that there was an reduction and was an agreement, and that by conduct and payment of the shorter amounts, that there was an agreement, then the amount would be less. You still got the 2 outstanding payments,
I said,
which
then
are in the invoice amount.
Yeah, then the adjustment should come.
Then the adjustment, Your Honour, yes. But if for instance you found that between that period of July 22 and April 24 that there was only $7,000 payable and that there was no shortfall, then that amount's not recoverable. But the first amount of the invoiced and not paid, so those 5 invoices that the defendant accepted in the WhatsApp messages that he hadn't paid, that's the 200,000. And then from May 24 until February 25, it's whatever Your Honour believes is the amount that's unpaid, whether it's 5, 7 or 10. So that's it would be possible.
May 24 to February 25, yeah?
Yes, Your Honour.
Yeah. But your case is still $10,000, unless the court found otherwise.
That's the primary case, that there was no agreement to vary. That was the evidence that Mr. Rahali, that is the claimant's case, that there wasn't any, that the agreement was just to reduce the amount temporarily until the cash flow improved, and that whilst there may have been an agreement on a lower amount being paid, it was contingent upon if something being signed and pay the invoices. So it was a deal. It was almost like you could look upon July or upon February as being like a settlement agreement, but a settlement agreement that the defendant didn't comply with, because as part of that settlement agreement, as part of that adjustment, they had to pay the outstanding amounts, and he didn't do that. So you go back to the original agreement. So yes, there may have been in the parties' minds the beginnings of a settlement or an adjustment, but it takes both parties to do their bit. And because technically there was never anything in writing, you may be able to get around that and say, well, I'm satisfied there's sufficient things going on and oral agreements and other documents that evidence an agreement. But part of that agreement was settle the outstanding invoices as they are. Even if you think there were 7,000, settle the remaining 7,000. He never did that. He never made any payments beyond December. And so we say any settlement or adjustment didn't crystallize. That's our primary position.
Would you like to address the court in the matter raised by Mr. Choudhury that the witnesses, defendant number 2, must not be a party to this case of proceeding, and he must not be jointly and severally liable for any amount, if any, to be decided against the companies, the defendant?
Well, Your Honour, when dealing with a limited liability company, the answer is easy, and it's basic that the limited liability company is a separate legal personality. It's sued and can sue in its own right, and any attempt to go after the shareholders or the employees directly is usually subject to some very stringent restrictions that allow you to pierce the corporate veil. So, for instance, if a company becomes insolvent and the company doesn't have can't pay off more than 40% of its liabilities, then there may be a case open against the shareholders if they've deliberately acted in a way to bankrupt the company, or they've transferred money off and damaged the company in some way. But in this case, we're dealing with a professional license. It doesn't have the benefit of that protection. And the owners of that company are, we say, not protected by any separate personality of the company. So the involvement in particular of Mr. Narayan, not his son, the other 50% shareholder, there's no case being brought against him, but he is the mind of the company, and he is also the arms and hands of this company. It's called a company, but it's a civil company. It's a professional license like lawyers get.
Yes.
And so bringing the claim against the company or against him is effectively the same thing. And we say there's no limitation on bringing a claim against him. He was acting as the company and as himself in all the circumstances of this case, even though contractually he's signing what appears to be on behalf of the company. He is the company. There is no distinction in that case. So that's the claimant's position on that.
Thank you very much, Mr. Yates. Let's turn now into Mr. Choudhury. Choudhury, please. You may please the court.
Yes, thank you, Your Excellency. Your Excellency, may I will divide my submissions into a few parts, and may I please begin by requesting Your Excellency to take a look at that Excel sheet, which is found at page 108 of the bundle.
Yes, it's open before me in a vertical basis.
Yes, yes. Your Excellency would have noted this morning that there are two entries that are isolated and remaining on the and remaining on the Excel sheet as missing. This is line item number 8 and line item number 21. I will just request Your Excellency to make a note that these are two invoices that are recorded in the Excel sheet of the claimants as missing. Now, Your Excellency, may I request you to also...
What do you mean? Is it missing or said to not to be paid?
Well, I was just reading off the Excel sheet itself. It's the claimant's wording that it says missing. I think what they probably mean is that it is unpaid, is probably what they're hinting at, but they've used the word missing. But be that as it may, if I may request Your Excellency to turn to page, sorry, I'm not sure what page it is, but it's in the contract, it is clause 3.6 of the contract.
There is a reference to the invoice number in these two missing ones.
Your Excellency, by reference, what do you mean?
Reference invoice number, for example, or dates or something.
Your Excellency, yes. If you see the second to last column, there is under the heading invoice number. It says WAG.
Yes.
Right. So those are presumably the invoice numbers that was assigned to the invoice when the claimant says it issued them. And of course, it's recorded in this Excel sheet as missing, i.e. probably unpaid is what they're trying to say. Mm-hmm. But if Your Excellency could turn to page, could turn to the contract, clause 3.6. I wonder what page that is on the, just a second.
You mean the referral agreement?
Yes, Your Excellency.
It's 59.
Thank you very much. Your Excellency, the 3.6 very clearly says that it's headed due date for commission, and it says the due date for payment of commission shall be as specified in clause 3.2. If the parties receive payment under any relevant contract in installments upon written approval of the first party, then commission shall be calculated and paid on such installments as and when they are received by the party and on receipt of the required invoice from the other party. What this invoice is effectively, what this provision is effectively saying is that invoices become payable upon receipt by D1, the defendant number 1, from the claimant entity. Now, we have heard from the witness today that those 2 invoices that I was referring to from the Excel sheet are invoices that he maintains in his evidence were not received by D1. This is important because the claimant in its pleadings has taken the trouble of filing certain invoices to argue that these are invoices that were issued and have been unpaid. It is our submission that if the witness of D2 is to be believed, the easiest way for the claimant to demonstrate that these are all invoices that were issued at an appropriate time for a lawful amount and remained unpaid is for the claimant to have supplied those invoices as part of the pleadings, just like they have done with selected other invoices that are made part of the case bundle. These invoices were generated electronically, issued and transmitted under the cover of emails. These emails are going to be part of the records. It is very easy for the claimant to just go back into their records, go to their sent message folder and extract the email under the cover of which those 2 invoices that are appearing in the Excel sheet as missing, i.e. unpaid, were transmitted to the claimant, to the D1, I beg your pardon. It is our submission that the witness's evidence that those invoices were not received and are therefore lying unpaid is an absolutely credible explanation of why those 2 invoices are still unpaid. It is our submission that if all invoices that were validly sent and received by the D1 have remained unpaid, the claimant, all they have to do is just make those invoices part of the records with or without the relevant covering email. And they have not done so. And they have not done so because we say that those 2 invoices in particular were never received by D1. And so on the question of whether those 2 invoices are lawfully paid, lawfully unpaid, or they have been paid, it is our submission that under clause 3.6, the witness's evidence being that those were not received by the D1 means the D1 cannot be held liable for those 2 invoices remaining unpaid. They were simply not received by D1. And because the liability to pay under clause 3.6, the last line says, and on receipt of the required invoice from the other party, i.e. D1 has to pay upon receipt of the invoice from claimant. And the claimant has not shown, we say, to this court's satisfaction, that those invoices were actually issued to D1. It is the easiest thing for the claimant to prove that it issued those invoices. They would have been sent in the usual way under some emails. I'll say no more on those 2 invoices, unless Your Excellency has any questions on that point, and I will then just move on to my subsequent points.
I think you should say more because 3.6 is not about waiver. 3.6 is about the due date of certain payment, for example. So you issue the invoice, we will pay you. So that's a trigger the direct payment. But then when you go to the original contract, it's like a renting fees. You have to pay for every month. Even if I didn't invoice you now, that doesn't mean I have waived the amount that to be paid. So I'm just thinking loud. I think so. We're not speaking about a waiver on here of the specific month's fees or commission or referral fees. I guess. But do you agree with me, even if the defendant, even if the claimant have not submitted a proper invoice at the proper time, but still that month money must be still available for the claimant when it's ever claimed?
Your Excellency, our submission is that under 3.6, payments are due upon receipt of an invoice from D1, from the claimant. These are businesses that are generating revenues. These are businesses that are owing monies to each other. But those monies become payable. They're payable, absolutely, but they're payable through a contractually allowed or a contractually agreed mechanism. And that mechanism is that upon receipt of the invoice from the claimant and received by D1, the invoicing of these monthly amounts, or whatever they may be, whether it was the original 10,000 or subsequent revised amount, these amounts are only payable upon D1 receiving invoices from the claimant, because otherwise there will be no need to issue any invoices. The contract can just agree to a 10,000, and the contract can just say that these are payable on the first day of the month or the first working day of the month, without their need for any mention of the word invoice, and specifically mention of the express words in that last sentence of 3.6, which says that on receipt of the required invoice from the other party.
Well,
So
we will keep that for Mr. Yates when he come back to talk about it. But it's because we know the source of the fees is not the invoices, but it's the contract itself, isn't it? So from
yes, the contract is a framework for what is due and what is payable and when, and what are the services to be performed and so on, and a whole range of other provisions. But upon the trigger for actually making the payment is actually a receipt of an invoice by me, by D1, from the claimant. And it is the witness's evidence that invoices were getting paid as and when they were received. Otherwise, it becomes very difficult to manage from an administrative point of view the outflow and inflow of funds if the whole invoicing mechanism is done away with or is not agreed as part of the agreement. There's a reason that the parties have said in this clause 3.6 when and how payments will be made. They will be made on receipt of the required invoice. The records will show that when invoices were generated for a significant amount of time, ever since the contract was executed, those invoices are received by D1. And then, of course, we don't have the date of the exact transmission of the funds, but upon receipt of the invoice, D1 would remit the funds to the claimant's account.
So in your defense, the two mentioned invoices that never been, let's say, issued, from your side, it's never been paid yet because there is no invoices issued. Is that right?
Yes. From the D1's perspective, it's D1's contention that those two isolated invoices
are not invoiced.
Have the invoicing has not been done. The invoicing, we'd like to assume that businesses are extremely organized and efficient with how they generate their paperwork. And we'd like to assume and believe that on the first working day of the month, the accounts teams are sitting down and creating all the invoices and sending them under emails to the respective recipient. But the way these very small one-man consultancies work is that they're working on a very skeletal workforce. And yes, invoices have to be generated and issued and received. And without an invoice being in my possession, I'm not obligated to make that payment. The other payments made have been made pursuant to invoices being received by D1 from the claimant.
I see. Let's jump to the next point.
Yes, Your Excellency. Thank you. Your Excellency, much has been submitted by the claimants about Article 15 of the contract. If I could request Your Excellency to turn to clause 15 of that contract. It's subheaded a variation, but I think I suppose we would classify it as a no oral modification clause. And the effect of this clause is that, look, no variation of this agreement shall be effective unless it is in writing and signed by the parties or their authorized representatives. But, Your Excellency, there is an exception to the claimant's ability to rely on this clause of the contract. And that exception, as we would all know, is Article 31 of the DIFC contract law. Unfortunately, that article, although the claimants have put up into the bundle various other excerpts of the DIFC contract law, this particular article is not there. Would Your Excellency have a copy of the DIFC contract law handy?
No, I didn't have it before me, but I can have a electronic database.
Sure. Your Excellency, in my PDF copy of that document, it's page 10 of the 40. It's the PDF page 10. Although in the internal pagination, it's page 5 of the actual document overall. And I will just read out to you what Article 31 says. I'm sure that Your Excellency already knows this, probably by heart. But the subheading is written modification clauses. And the provision says, a contract in writing which contains a clause requiring any modification or termination by agreement to be in writing may not be otherwise modified or terminated, which is the first proposition of law that exists in that article. It then goes on to say, however, a party may be precluded by its conduct from asserting such a clause to the extent that the other party has acted in reliance on that conduct. What we say the effect of this Article 31 is that although clause 15 of the contract continues to subsist, and we are not trying to invalidate that clause, what we are saying is that Article 31 of the DIFC contract law is an exception to the applicability of clause 15 of the contract. And we say so because there are enough documents on record to show that the claimant has, for a significant amount of time, been invoicing the defendant one entity for an amount that is different from the amount that was initially agreed when the contract was entered into. Specifically, from 10,000, it became 7,000. And it is our evidence and our defense that the 7,000 was, in fact, the amended amount of commission payable by D1 to the claimant. And these are two businessmen who have had a history of dealing with each other. They have been communicating with each other over WhatsApp. Your Excellency has seen the nature of those WhatsApps. It's very informal. It's very casual in its language, in its sentence structure, in the way communications are conceived and exchanged. There are emojis, emoticons. There are very colloquial expressions being used between the parties. And that, we say, is exactly reflective of the parties' relationship. They were not just two businessmen, two large corporations transacting with each other on an arm's length basis through their professional advisors, lawyers, and other professional people that they have on the board of the companies and so on. These are two relatively smaller entities, driven, operated, run by their respective owners on a very personal, informal, casual basis. And that is made out from the nature of the language that they have both used in their WhatsApp communications. And we say that the invoicing by the claimant, all the way from for services rendered in July 2022 onwards, that is obviously the Excel sheet that was being addressed earlier, that shows that the 7,000 was being invoiced, because we say it is a reflection on the amended amount that then became payable from the respondent to, sorry, from the defendant number one to the claimant. We also say, Your Excellency, that it is common ground that up to November 2023, an amount was received by the claimant from D1. And of course, it is a separate issue whether that amount was part payment or a full payment. We say it was a full payment of the amended amount. But what is equally interesting is that Your Excellency would have seen invoices that have been made part of the bundle. If I could request Your Excellency to turn to page 78 of the bundle.
Yes.
Your Excellency, this is an invoice which is dated 8th of January 2024. Under the item and description subheading, it says invoice for the month of December 2023, and it says $7,000 at a certain conversion rate, and then it gives you the dirham equivalent. We also say that if Your Excellency could turn to page 92 of the same bundle.
Yes, 92.
This is an invoice that is dated 9 days after the invoice I had just shown Your Excellency earlier. This invoice is for 17th January 2024. Sorry, dated 17th January 2024. The amount here is a different amount. That amount is equivalent to $5,445. And we say this invoice is referring also for services rendered in the month of December. And we say that because it is common ground that up to November 2023, the $7,000 invoiced had been paid by D1. And so the only month in between November 2023 and the date on which this invoice was issued is only the month of December 2023. So what we have are two invoices for the same month for different amounts. One is for 7,000, one is for 5,445 approximately. And now we come to the evidence of the witness, D2, who on page 52 of the bundle, which is his witness statement, if I could ask Your Excellency to turn to page 52 of the bundle, which is part of his witness statement.
Yes.
That is the start of the witness statement. The subsequent page, paragraph 15, 1.5. In paragraph 15, he says, in late 2023, I proposed to reduce the referral fee further to $4,000 per month. The claimant counteroffered $5,000 per month, which was agreed upon, and invoices were raised accordingly. So it is our evidence, and this evidence is, we say, credible evidence, because not only is the witness himself saying that he agreed to a lower amount with the claimant entity, but there are two documents that are issued for the same invoice, but those invoices were for amounts different to what was agreed upon between the two parties. Neither of those two invoices were for the $5,000 that the witness says was agreed between the parties. One is 5,445. We don't know why they issued an invoice that is larger than the $5,000 that was agreed. But whatever the reason may be, that was not a valid invoice. And so for December 2023 onwards, for invoices for an amount that is larger than 5,000, these are unlawful invoices issued by the claimant in violation of the revised agreement that the two parties had reached. And therefore, the defendant number 1 is entitled in law to not have made payment of these invoices. The claimant has itself submitted these 2 invoices for the same month. This is their documents on their letterhead. This is just their usual invoice, as we've seen in other parts of the bundle. And we say that this is absolutely what Your Excellency might classify as a smoking gun. The smoking gun because it shows that the claimant itself has been taking contrary position by issuing conflicting invoices for the same month to the defendant 1 entity. And when it had a change of heart, it then started invoicing for larger amounts. And then, of course, we then have a dispute, and therefore amounts were not getting paid, and the lawyers got involved. And then you have the genesis of a dispute culminating with this trial. Your Excellency, this in the morning's proceedings, the witness gave evidence that his joining the first client, Britannia, was something that was very much part of a 3-way discussion between himself, between a gentleman who has been referred to in the WhatsApp as Dan. Dan is a person who is part of the management of Britannia, and Mr. Rahali. It was his evidence that Mr. Rahali congratulated the defendant 2 for being able to really cement that association with the Britannia group. Because had that not happened, then in the WhatsApp that Your Excellency has seen, there was an expectation that the Britannia group would have brought in personnel from elsewhere, perhaps recruited from elsewhere in the market, or personnel who have been transferred from elsewhere in the UK or somewhere else. But that would have meant a termination of the contract under which the claimant stood to gain in the form of many thousands of dollars a month. So we say that in the WhatsApp, which was put to him during his cross-examination, he says in his WhatsApp to Mr. Rahali, as you know, I had to move to BGSML payroll. And as you know, is reflecting the position that the 3 persons, Dan, Mr. Rahali, and the witness, have already had numerous conversations about how to strengthen the association of Mr. Narayan with the first client, Britannia. This was not news to him. This was not news to Mr. Rahali. This was something that was already known to him, because we say, as the witness has testified, Mr. Rahali was part of the conversation and was congratulating Mr. Narayan on cementing, strengthening a pre-existing lucrative relationship, one that is lucrative for both of them. After Mr. Narayan joined Britannia, he continued to receive the amounts that we say was lawfully owed to him. So, of course, he continued to gain. He would gain for as long as Mr. Narayan would continue to perform the service to the Britannia group. The reason he stopped gaining is because the claimant entity started invoicing D1 for amounts that were greater than amounts that were already agreed as an amendment to the $10,000 commission payable. Your Excellency, I don't have much more to add, except to just request, Your Excellency, if you have any further questions for me at this stage.
Thank you very much. I'll refer to Mr. Yates and I might come back to you later.
Thank
Mr.
you.
Yates.
Your Honour, thank you. There are just one or two matters I'd like to come back on. Of course, the defendant's initial response to the invoices that are allegedly still to be paid was not that he hadn't received an invoice, it's that he'd paid them. That was the document that he sent in the WhatsApp message, and the defendant's case has always been we paid those amounts, which is why the response that I put to him, that you could have provided bank statements showing the transfers, would have demonstrated that he'd paid them. And then it's a new position today to say, oh no, we didn't have the invoices. So it's not for the defendant to say that the claimant should have provided copies of all the invoices that it said it delivered. It's the defendant's initial response was that we paid those. So that's the first point I'd make on the invoices. The second one is that Your Honour's right. The obligation to make a payment comes from the contract, not from the receipt of an invoice. So whether or not they've received an invoice, that payment is payable for that month. The third point to make is that once the claimant sent to the defendant a legal notice, that's the trigger for payment, and they didn't make the payment then either. So those are three quick points that are against my learned friend's suggestion that there was no invoice, and in fact the defendant's suggestion that there was no invoice. Turning to the law, the Article 31 of the DIFC contract law, I have the laws of the DIFC and can refer to that. And in fact, Your Honour, once you opened your copy to hand, it's on page 19. Written modification clauses, it says, and following the PICC, are acceptable, although a party may be precluded from by its conduct from asserting such a clause to the extent that the other party has acted in reliance on that conduct. So it's a sort of estoppel argument that if you've done something else and the other parties acted upon it, doesn't say to their detriment, but it says here that they've acted upon it, then it may be discounted by the court. But in Emirates Capital and Monte Carlo Stars Restaurant, a DIFC case, the first instance court refused to find that the parties had modified the contract in a manner other than in writing. Now, the points that I make on this is that the defendant's response to modification now goes to three things. It goes to whether or not it was okay for him to go work personally, that would require a change to the contract. Then it's to do with the change from $10,000 down to $7,000. That would require a change. And then it's the modification from 7 down to 5. Now, the defendant's claim, it seems, up until today, had been that conduct demonstrated that there was an agreement. But that changed today when we heard from Mr. Narayan, in that he says actually it was in writing, and that the WhatsApp communications that appear to demonstrate there wasn't an agreement actually demonstrate the opposite if you were to see the full versions of them. But they have been lost because he lost his phone. Now, at no point has the defendant made a request for the claimant to provide the full versions of those conversations. So even if he's lost his phone, Mr. Rahali has his. The defendant could have said, no, we'd ask you to provide the full conversation because later in that conversation, there's an agreement that's reached. It just looks as if Mr. Narayan's made it up, that's what it looks like today. These are just non-credible responses. So the variation point, you have to accept that there was a variation and that the defendant relied on it to be able to go behind the clause that says any changes must be in writing. But I highlight the flip-flopping of the defendant in this respect, in that we don't know if it's oral or it was written or it's inferred by conduct. They keep changing their position on it. We say none of it is, in fact, credible. And in fact, this embellishment that we now have of the July meeting of some kind of celebration or congratulation doesn't appear in the witness statement. The witness statement on variations at paragraph 15, the second defendant speaking about the change in late 2023, seems to be talking about November or December 2023, but he doesn't say specifically what month it was in. That's vague. And nor does he say, actually, it was in writing. It was on WhatsApp, but the WhatsApp message isn't complete. So the witness evidence is very vague and not trustworthy. Again, paragraph 14 of the same witness statement, he says that the agreement was varied from 10 to 7. Doesn't say it was in July, just says it was varied, just following negotiations. So he doesn't give a date, and nor does he say that it was written, and nor does he say that his phone was lost. So it's difficult to attach any credibility to these statements, which are on the point of whether there was a variation to the contract and what is needed to approve that. We say that even though the contract law allows for the court to infer that there was a change, there was an agreement, and the conduct demonstrates that the defendant hasn't proved that in this case.
Thank you very much, Mr. Yates. Anything to recap with Mr. Chaudhary?
Your Excellency, thank you. Just one or maybe two very minor comments. It won't take up much of the court's time. Your Excellency, clause 4.3 of the contract, which was referred to by me yesterday, that clause is Your Excellency will recall that I had made the point that under that provision, it is permitted for D1 to transfer the provision of the service, the delivery of the service to a third party. And it is the witness, it is D2's witness that not only was Mr. Rahali aware of this, he was informed, he was part of the discussions, the three-way discussions that happened in the build-up to his being transferred and getting onto the payroll and onto the visa of the Britannia Group. That transfer happened with Mr. Rahali's consent, blessing, all because Mr. Rahali himself and his entity, rather, stood to gain commercially from the continuation of the association between the witness, D2, and Britannia. Otherwise, the risk was that Britannia would bring in someone else, and that would end in a termination of D1's agreement with Britannia, and then that would result in a revenue loss of many $1,000s. At that point in time, it looked like for many, many years to come. Of course, as we know, subsequently, that ended in February of 2025. And my second and last point, Your Excellency, is that the $7,000 invoices that have been issued and some of which are part of the records of these proceedings, these invoices are well conceived, well formed. These are not very casually created invoices. Nowhere do these invoices mention that this amount is different from the contractually applicable amount, because we are in some sort of a settlement agreement stage, and the balance of $3,000 remains due, but it does not become payable until a certain trigger event happens. There's no allegation. I mean, there's no evidence of any cash flow crises or any other generosity from the claimant being the reason for the 10,000 invoicing becoming a 7,000 invoicing. These invoices are simply just like the other invoices. There's no difference in them, except that the amounts are a reduced amount. If you as a claimant are generating your invoices on a monthly basis as a temporary concession to D1, it wouldn't have taken them much to add, to clarify that this 7,000 is actually not a full and final amount for the month in question, but it is only a 70% of what remains due and will be payable in due course. So in our submission, we say that this is very much conduct from the claimant's side, which means that the claimant is stopped from now saying that the original contractual term of $10,000 continues to survive and continues to be payable, applicable, starting from services rendered in July 2022 onwards. Your Excellency, I have no further submissions to make unless you have any questions for me.
So apart from the two invoices we just mentioned, we have seen in the Excel sheet, do you deny there is, and apart from also the disagreement over the variation, is there any other invoices that have not been paid in full by your client until your client received the legal notice to pay in full?
Your Excellency, if I heard your question correctly, on that basis, I will just respond. And please correct me if I'm answering a question that you did not ask. Our case is that those two stray invoices for May 2022 and June 2023 are invoices that were not issued by the claimant to a D1. The remainder of the invoices that remain unpaid, i.e. invoices for services rendered from December 2023 onwards, those are invoices, as Your Excellency has seen, there are two invoices for the same month. One is for 5,445 and the other one is for 7,000. We say that from that month onwards, the claimant has been issuing invoices for an amount that is different from the then agreed amount, which was 5,000. In December, they issued two invoices in January, they issued two invoices for the same month. That itself was the starting point of a series of invoices, which was for an inflated amount. And then, of course, it became a full-blown dispute. And at that stage, D1 was entitled to not pay an inflated invoice because they were greater than the $5,000.
Could have they paid the 5,000, for example, agreed monthly? I mean, despite the claimant is being issuing a greater amount invoicing, but could the defendant mitigate this kind of, I don't want to call it a breach or disagreement?
Your Excellency, that's a good question. Your Excellency, I think what the defendant did was comply with the contract. The contract in our submission, I know my learned friend has made a different submission on this. In our submission, the contract, under the contractual term, amounts are, of course, due and payable, but they become due and payable upon receipt of a valid invoice by D1 from the claimant. And in the absence of a valid invoice, under the express term of the contract itself, no amounts fell due, although amounts are payable under the contract. This contract continued to subsist even back then. But if you're going to be invoicing me for inflated amounts, I should not have to pay it.
Clear.
Thank you.
Thank you very much. Thank you very much for both counsels. Thank you very much for the team behind. Thank you. I must reserve for judgment, not for a long time. I'm expecting this to be in 2 or 3 weeks' time, hopefully. I will not invite you from now to submit for cost. I usually would invite you when I deliver my judgment. I will invite you to make submission related to cost to reflect the outcome of this court judgment. For short submission over short period.
Right. Thank you, Your Excellency.
Mr. Yate, you okay with that?
Your Honor, yes, I'm just taking instructions on one point, and I'll tell you what it is. That if we wanted permission to appeal on the decision on the application, then we're going to be out of time by the time you give us the decision on the main case. 21 days. So I'm asking if you would grant permission to appeal on the decision on the application, whether to adduce Mr. Rahali's evidence.
If you apply for extension, maybe I'll grant it.
Yes, I'm grateful, Your Honour. Thank you.
Thank you very much. Thank you very much, both counsel. Have a good day ahead.
Thank you.
Thank you. Thank you. Goodbye.